I'm Maureen McGlynn Flanagan. I will be talking about the public records law for the next hour plus. Before I start, I know that there are quite a number of you who work for government agencies, so I assume you're here just because you want to know more about the public records law or because you are in a position to have to comply with the law. But if the rest of you, I'd be interested to know how many of you are here because you're basically people who are interested in getting access to records and want to know more about that. Okay, and are there those of you who are here because you advise government agencies or advise people regarding the public records law? Okay, thank you. As I say, that information is just helpful to me. I'm going to give you a telephone number. Tom talked about the fact that we try to be a resource for people. We certainly encourage you, if you have access to legal counsel and you're a record custodian, to take advantage of that. There are other entities that are available as resources to local units of government, for example, the League of Municipalities and the Towns Association. I know those organizations have people on staff who are quite knowledgeable and quite helpful. But our office also tries to be available to the public, to other government agencies, etc. The phone number is for Connie Anderson, who is the lead attorney in the unit that Tom and I work in. Connie's phone number is 608-266-3952. If you want to call us, because of the fact that all of those of us who do this kind of work have other caseload requirements, we have other responsibilities, we're not always in our office. And if you are interested in getting a quick answer, Connie knows who's most available, who's not having a stress attack that day, who may know more about a particular subject than somebody else, and she does try to funnel calls in that way. So I encourage you to use that. Basically, I want to talk today about the basic terminology of the public records law, what records can or may not be released, so access issues related to the public records law, discuss some of the challenges of complying with the law, and just provide a basic framework for you to analyze questions. The law itself is outlined in this outline. We've spent a good deal of time trying to collect resources and information, citations to statutes, cases, and authority that would be helpful. And it also is posted on the website. The website address is on the inside of the booklet. Unlike the open records outline, we do not have links to materials at this time. The reason for that is that most of the links, most of the citations to authority in the outline are cases. And there are various copyright and other problems related to having a link to case materials, especially case materials that predate the public case reporting that the Supreme Court instituted, I think, in 2001 or 2. So, but this does have resources in it. It has the statute itself as it appears in the statute books. It has a sample public records notice, the one that the Department of Justice uses. Obviously, that would have to be modified to suit the particular authority's needs and policies, but it's at least a guideline. Like Tom did, I I am going to talk a bit about the statutory policy that is set forth in 1931 of the statutes. For those of you who are lawyers, I know that most of you are familiar with the fact that the first section in many statutes is some sort of statement of public policy about why the law was passed or why it's important. And mostly, I don't pay any attention to them when I'm researching the law. But with regard to the public records law, this can be a complex area, and I think that the sort of compass that you can use to figure out questions about the law is really set forth in 1931. It is quoted in one of the first pages of the handbook, but there are 4 points that I want to just highlight for you because I think they're really key to figuring out where to go on public records questions. The statute provides that providing information on the affairs of government is an essential function of representative government, an integral part of the routine duties of officers and employees whose responsibility it is to provide that information. To that end, the statute shall be construed in every instance with a presumption of complete public access consistent with the conduct of governmental business. Now, the points that jump out at me when I look at that is that it's an essential function of representative government, and I don't think that it's possible to overemphasize that point. I mean, we're all committed to having a representative democracy, and having information, having an informed electorate, having the public knowledgeable about the affairs of government is key to that. And it's also very useful, I think, for those of us who have public records responsibilities to remember that when you have 85 things to do today and somebody's bugging you about a public records request and you really are getting anxious about what to do. I think it's very useful to remember that this is a critical part of how our government works. That flows into the next point for those of us who have records custodian responsibilities, and that is that it's an integral part of the routine duties of officers and employees. That means that no matter how many other demands on your time, you have to work it out. You have to give some priority to responding to public records requests. You can't just sit it on that pile that's over there on the far right-hand, left-hand corner of your desk and that kind of keeps floating down to the bottom. You have to figure out a way within the time constraints of your job to respond and to respond reasonably. The final point is really 2 in 1, that there's a presumption of complete public access consistent with the conduct of governmental business. The presumption of complete public access is, as Tom pointed out early on in his presentation, it's the tiebreaker. If there's not a clear statute saying it has to be withheld or it has to be released, and you're under what's called the common law balancing test, and the answer seems to be kind of half of one, half a dozen of the other, the answer is that the balance needs to tip in favor of access. But it doesn't say presumption of complete public access, period. It says a presumption of complete public access consistent with the conduct of governmental business. And I see that as writing into the statute a recognition that there are times and there are circumstances under which particular records must be kept confidential or need to be kept confidential at a particular time. And as I say, I think this is written into the statute. So when you try to figure things out under the public records law, it seems to me that using these statutory policies together with just plain common sense, common courtesy, and just a gut check are the most useful ways. You don't have to be, a law review attorney to do this work, but you do have to think carefully about what the duties of government are and what the interests of the public are. Now, for a while, I'd like to talk about some of the key concepts in the law. These may be pretty basic for many of you, but I find in answering questions from the public, in getting phone calls and getting correspondence, that we almost always have to start with the basics. We may not end up there. There may be quirks and complications, but keeping in mind these kind of basic terms is a useful way to start. First of all, what is a record? The statute makes clear that it's defined in 1932 too, and in the case law from the common law decades and hundreds of years ago. It's clear that a record is information that can be collected on virtually any kind of media. The statute makes that very clear. Written, drawn, printed, spoken, visual or electromagnetic information that is recorded or preserved. So the medium is almost never determinative of what a record is. What is determinative is whether it is maintained, created, or kept in connection with official business. That is really the key. So location or medium don't really determine whether it's a record or not. The substance and the relationship to the workings of government are what is determinative. That is one of the key reminders that we have to go through with some of the quirks of developing technology and the fact that information can be just about anywhere. And we have to, for a custodian, that has to be something taken into account. Now, of course, there are a number of materials that are excluded from the definition of records. Probably those of you who are familiar with the statute can recite several of them right off the top of your head. The ones that are most obvious in the statute are notes and preliminary computations, drafts that are kept for personal use. It also excludes published material that is subject to protection by copyright. And so that can be an issue with regard to certain kinds of records. Another key thing, and I think this is inherent in what I have already said, is that the same rules in general apply to electronic records as apply to paper records. The challenge in this day and age is really applying applying a law that was written clearly with paper records in mind originally to the developing technology that we have. And as I say, that can be a challenge, but there's no question about what we have to do it. There are procedural requirements that apply to authorities. Authorities are basically governmental bodies and Tom, I know, spent some time in his discussion on that. Generally, in the public records area, you don't have really, it's not real common to have a question about whether or not the entity is a governmental entity or not. The only real questions that come in have to do with certain kinds of quasi-governmental bodies. which is an issue that's pending before the Wisconsin Supreme Court. So we may have some guidance on that within the next few months, I believe. But in general, if you're a governmental body, look like a governmental body, walk like a governmental body, you can just assume that you are subject to the public records law until somebody tells you otherwise. And that's not very apt to happen. Now, I'd like to spend a little time talking about requests and requesters. Again, basics, but it's handy to go over them. Now, who is a requester under the law? Anybody basically can be a requester. There are limitations on two categories of people, incarcerated persons and committed persons have limited rights to access to records under the public records law. Their access is limited to records that contain personally identifiable information about themselves or that about their minor children for whom they have not been denied custody or placement, I believe is the language of the statute. So other than those individuals, and I suppose I've often wondered if minors theoretically are requesters under the statute, but I think that's one of those angels on the head of a pin questions that doesn't really matter. I think you can just basically assume that just about everybody is properly a requester. They don't have to identify themselves, except with respect to very limited kinds of records that are covered by particular statutes. But ordinarily, the requester does not have to identify themselves. They don't have to put their request in writing. Now, there may be some very good reasons to put a request in writing, or there may be good reasons for the custodian who's handling the request to reduce an oral request to writing just for business purposes of handling the request. But except, again, with particular kinds of records where the statute allows certain kinds of special regulations for access, you don't have to reduce your request to writing. Now, why would it be a good idea? First of all, if you're a member of the public and you're seeking access to records, and it's not the kind of record you can just walk up to the counter and the clerk is going to make a Xerox right then and there and hand it over to you, it's just a business-like way to do it. It may be the reason that the clerk who takes your oral request writes it down. We regularly get complaints from people who know that you can't be forced to make a written request, who question the fact that a custodian might write the record request down, and basically, you know, it's just a business-like thing to do, and there's nothing wrong with it at all. But the reason from the requester's perspective that it may be important to reduce the request to writing is that unless it is reduced to writing, and there's that kind of documentary evidence of exactly what it was you asked for, you can't seek enforcement under the law. In other words, having a written request for a record that's been denied or the custodian has not responded to your request is a prerequisite to any kind of enforcement. So if you're a requester who's concerned about that, that's a good reason to do it. Now, obviously, if you're a custodian and you're dealing with complex or unusual kinds of records requests, it's a very good idea to try to work with the requester to make sure that you know exactly what is being requested, and it gives you an avenue to kind of work these kind of things out. The requester, again, not only does need not state a name, they don't have to state a purpose. They cannot be required to state a purpose, again, except for certain very specific kinds of statutorily covered records. Now, the fact is, sometimes if you have a request that's somewhat vague or difficult to understand, talking to the requester, calling the requester, having some sort of correspondence by email or otherwise is a way to figure out what it is they're really after. So while we advise people not to demand what the purpose of the request is, there's nothing wrong if you're trying to figure out what the requester is really after to try to get a little context for the request. But again, they cannot be required to state a reason. Now comes some of the problem areas for custodians and for public records requesters, because obviously if you're a requester and you're human, you'd like whatever it is you've asked for yesterday, or at least right now. And so, but most people understand that's not possible. And the public records law does not give you a clear answer on that. This drives some people crazy, people who really like rules. It drives them crazy, and I'll get to sort of a rule of thumb in a minute, but I think the public records law says that a response must be provided as soon as practicable without delay. I mean, if you've been around the statute long enough, you could say that backwards probably, but that is a recognition in the law that the public records law is intended to apply to a huge variety and range of records. It's intended to apply to a real substantially differing kinds of requests or differing kinds of records, so that the statute is written so as to make clear that, as I indicated earlier, you have to give priority to responding to the request as soon as practicable without delay. And you can't just ignore it. On the other hand, if you have, say, a large number of public records requests, so you've got a tension between who gets answered first, or you have many other non-discretionary demands on your time, that's where the custodian really faces the challenge of figuring out how to do this. One of the things we recommended for years, and it's quite well known, I know, among various members of the public, is that we have recommended, despite the fact the statute doesn't say a time limit, that the custodian try to respond within 10 working days. Now, that response, at least the initial response, could be, I want to acknowledge your request. We are working on it. We anticipate that it'll be some estimated amount of time, or to give the requester, many of whom are really convinced that if they don't hear something, that they're being ignored, and sometimes they're right on that, that to give the requester the assurance that, yes, you have it, it's been logged in, you will get a response. And for requesters, again, I simply recognize if you're feeling like you haven't gotten a response and it's been a reasonable amount of time, by all means, contact the office. This is an area where just common courtesy and good sense go a long way. Sometimes people have some sort of a confrontational mindset built into this situation. I'm sure those of you who are clerks and custodians really try to work against that. You're there to serve the public. But common courtesy and just sharing of information to the best you can is a way, from the custodian's perspective, of avoiding unpleasantness or even worse, litigation. And I really can't emphasize how many times in the cases I've handled or have had contact with where a little courtesy, or maybe a lot more courtesy, would have really resolved the problem short of litigation. Now, sometimes there really are strong legal questions involved, but I can't emphasize enough that this is an area where custodians and requesters need to try to work together to understand, for example, with regard to a request. I talked about the fact that it doesn't have to be in writing, it can be oral. There are some limits on requests. The public records statute requires that the request reasonably describe the record requested, that it be, and goes on to say, and this is section 1935, 1H or L, I can't remember, but it says that a request that is not reasonably limited in time or subject matter is not a sufficient request. Now, if you're the custodian and you get a record request for all correspondence that a particular work unit has generated, including email, of course, for the last 7 years, what is the first thing you do? Contact the requester and tell them, I'm denying your request. This doesn't reasonably describe the record that you're seeking. No, I think it gives both the custodian and the requester an entree to try to work it out, for the custodian to explain what the difficulty it is to answer such a broad request, what the cost might be if the requester is really serious about wanting that kind of records, and you're talking about physical searches of records or sorting through a large volume of materials. So there is a basis in the public records law to work on and it's in the requester's interest often to try to identify reasonably, in reasonably clear terms, what it is you're after. I know very often requesters will ask, they don't want to miss the one key record that they're really after, and so they'll ask the request in such a broad way that it kind of potentially could include everything, everything in some particular work area or something like that. The first thing I would suggest doing is to contact the requester and confirm, what it is they're focusing on, because clarifying a request is very helpful, oftentimes. Now, if you're responding to a request and you're going to hand the record over, great. That's all you need to do. But if a request is going to be denied completely or in part, there are some serious obligations on the custodian, and it's very important to bear in mind what these limitations or requirements are. First of all, the custodian has the obligation, if part of a record is confidential and part of a record is not, to separate out that part that is that can be disclosed, and disclose that part of the record. So the law itself imposes that kind of obligation. That brings up a little tangential point that comes up, and I will try to spend a little time talking about costs at the end of my remarks. But there is a debate going on about the costs of separating the confidential information from non-confidential information. Our office has traditionally taken the view, especially with paper records, that if you're going to be blacking out part of a record that you're going to be providing to the requester that we don't think the statute authorizes the charge for that kind of cost of processing. That position is in some tension with a case that was decided by the Supreme Court about 3 or 4 years ago called Osborne versus Board of Regents. In that case, the Supreme Court went out, well, I don't know whether it went out of its way, but it made very clear in that case, which involved a request for a very large volume of electronic records, that the requester could be required to pay the actual necessary direct costs of producing that information. And I think, and I think it's discussed in the outline, I really think that is a difference in kind. There is a tension in the statutes. The statute says in one place that the custodian cannot be required to compile a record. Now, there are some exceptions to that, and you need to look at the statute. But in general, a custodian can't be required to compile a record. But in the area of electronic technology, this is where there really is some uncertainty in the law. I think the case that I just cited, the Osborne versus Board of Regents case, and there was another one in the last year or two, which quoted the Osborne case that the requester can be required to pay that kind of programming cost. I think it really kind of boils down to, or it may anyway, boil down to a recognition that, at least in the processing of paper records and separating out pieces of information in that arena, is really different in kind than the kind of operation that goes on when you're essentially compiling a record from bits and pieces of electronic data. And I know that this is an area where there's going to have to be some growth in the law. There is some litigation on it already, but it's a difficult area. And it's an area where if you're faced with that kind of question, I think you need to not give a knee-jerk answer. Try to consult with counsel. Call our office. Check with the resources you have if you have that kind of question. But back to the responding to a request. If you are going to deny access to a record, the public records law is very clear that the custodian must state a specific, clear reason for denying the request. And in fact, it behooves the custodian to state all the reasons. I mean, maybe you have one reason, but that you think is a really good one, but there are several other concerns as well. First of all, the statute's clear that you must do this, so the statute doesn't give you discretion about this. I think that a well-written denial letter, at least in a situation where there is room for doubt, or if there's a clear statutory exception that says no, that record doesn't need to be produced, all you have to do is cite that statute. But if you're getting into what I'll talk about in a little while, the balancing test, the better you explain yourself, the more likely it is that the person who's been denied access to the record may say, okay, I would still like to have the record, but I understand the reasons in this instance, and they strike me as reasonable. At least there's a chance of doing that. So there's a good reason for the custodian to try to write a well-written denial letter, even if the law didn't require it. But the fact is the law does. From the custodian's perspective, the reason you must write a specific response denying a request that is as complete as possible is that the case law is very clear that the reasons that you state in the record denial are the reasons the court is going to look at. So if you had 3 reasons and you just put one down and you get sued about it, the court is going to say, well, maybe that would have been a good reason, but you didn't state it and we're not going to look at it. Now, sometimes they bail custodians out, especially if there is a specific statutory exception that might that applies. But the reality is 9 times out of 10 they don't. And so, as I say, a word to the wise, if you're denying access to a record request, you need to be as specific and as full in your statement of reasons as possible. I've been rambling on here at quite a great rate of speed. Does anybody have any questions at this point? As I say, feel free.
What was the reason for denying inmates? Was it just the fact that some of them had the habit of making annoying requests?
Well, the question was, what was the reason for changing the law to limit inmates' access? And, the legislature in its wisdom did it, so it's not ours to question. But I do know, as a kind of background, that there was for a while a kind of cottage industry among inmates who had discovered that if they sent some poor clerk somewhere a request for a record and the clerk didn't recognize it as a public records request or whatever, that the inmate was entitled to statutory costs, which is $100. To statutory damages, which is $100 plus their costs, so that there was a little cottage industry going there. And in a way, it's too bad, because I certainly have seen requests for information from inmates that are legitimate, that go beyond the limitations in the statute. But the fact is that is written into the statute, and you're right, it was written in there to kind of curtail, very specifically to curtail inmates' rights to kind of make a buck. Go ahead.
Excuse me, are the agendas of an open meeting themselves an open record? Might seem self-evident.
The agenda would ordinarily have to be posted with the notice of the meeting, and I think by definition would be a record that's available to the public. Now, if your question goes to how specifically do they have to state their reasons about
in this instance,
closed.
There was a second agenda that was more detailed than was posted in the next.
Okay, your question is that says that there was a second agenda and so what is the question? Whether that would be available to the public?
Yeah, whether the second more detailed agenda would also be public.
Well, I would think ordinarily, but first thing I'd suggest is that you ask. I don't know why it wouldn't be public, but I don't know exactly what facts you're talking about. I do know that there are occasions where materials are distributed to members of governmental bodies in advance of the meeting, and say those materials are going to be discussed in closed session. The law is clear, and I'll be getting to this in just a minute. The law is clear that access to those materials can be limited as long as the reason for closing the meeting continues to exist. Agendas are kind of those kind of things that are sort of like the approved minutes of a meeting. They're kind of per se available to the public, but since I don't know the factual context to your question, I'm just fudging a little here. Go ahead. The question is, clarify when a draft is a draft and when it's not a draft. Well, I'll try. But it's a very fact-specific issue. There's an Attorney General's opinion. There's also a case, the Fox case that's cited in the materials that addresses when a draft ceases to be a draft. And basically, the statute says that when the document is used for the purpose for which it was intended. So, for example, the case I'm thinking of involved what was stamped as a draft settlement agreement in some kind of litigation, and then it was stored in the office of the attorney for the private party that was suing the school district or the municipality. But they had actually acted on that agreement. The agreement had been put into effect, so the court didn't have a lot of trouble in that instance in saying, no, this document, you can't take it out of the public records law by labeling it a draft or calling it a draft when it's been used for the purpose for which it was intended. Another limitation that is discussed in the AG opinion that's cited in the materials is the kind of document that's circulated within a government agency and for comment, before it's final. Now, if this is a document, let's just take AG opinions, for example. In our office, we're asked for the Attorney General's opinions on a wide variety of things, only some of which we're willing to opine on or have the authority to opine on. But the process is such that somebody drafts that, and then it's circulated to a bunch of other people for review and comment, criticism, etc. And that's all done before it goes to the AG for a signature. Now, I would consider those kind of circulated drafts within the agency that are circulated under the level of the person who has the final say-so on whether or not this is going to go out or not. I think that is legitimately considered a draft. Now, where people get into trouble is there are instances sometimes where there are interagency kinds of things. Now, given that AG opinion, I'm not sure it qualifies as a draft. There may be other reasons under the balancing test that might, in a particular case, justify withholding it based on the preliminary nature of the material or so on, but I'm not sure I would consider that a draft. Basically, I think the safe thing to do if you're trying to figure out if something is a draft or notes or not is this something I've produced for my work product. If it's in that preliminary stage, it's clearly notes or clearly a draft. When you go beyond that, when you circulate something outside of the scope of the authority of the person who has the final say-so on it, the Fox case says quite clearly that it's no longer a draft. So those can be tricky questions at times. There are obviously sound policy reasons under the law for not having to produce every scrap of notes or draft that you've ever produced because they don't represent final work product. They don't represent an official statement. But there can be some interesting questions about whether it's a draft or not. Now, go ahead.
Would you agree that if my boss says they would like to approve a letter that I, the employee, am sending out, that I can circulate it upwards as a draft to my boss, and then I send out the final signed version with their changes, but the draft version I would not have to produce?
Well, I think it's, I think the key is whether or not the boss approves. If it's going out under the boss's signature.
My signature, not the boss's, but the boss still wants to approve it.
Well, it might not be a draft. I'm not sure that it would, I think you might have to apply the balancing test there if you were going to be asked for it. And I don't know what the answer would be. It'd probably depend on whether the boss did in fact approve it or something like that. But the draft thing can be really a conundrum at times, and it can create some difficulties. Okay, one question.
Okay, if it's a situation where there's a formal legal discovery request, is that handled differently than an open records request? And can that be broader in scope?
The question is about the relationship between a public record request and a legal discovery request. And the thing you have to remember is they are two different avenues of access to materials and information that are held by the government agency. Some of the limitations on access to public records do not apply to discovery. For example, drafts and other kinds of materials that wouldn't be considered records under the law may be accessible in discovery. At the same time, in discovery, you have limitations on the scope of the lawsuit. So if it's not likely to lead to discoverable information or the information that's relevant to the issues in the lawsuit, then you may not have an enforceable right. So the thing to remember about legal discovery in the public records law is that those are independent avenues of access, and there is a case that the Wisconsin Court of Appeals decided 15 years ago or so that makes that clear, because the attorney in the lawsuit had blown his discovery deadlines, which happens occasionally with attorneys, and so he or she, I think it was a he in that case, made a public records request for information that he could have sought in discovery, and that request was denied by the custodian on grounds he was trying to make an end run around the limitations on discovery, and the Court of Appeals said, no, tough. This is an independent remedy, and if it's accessible under the public records law, you have to give it to them. So that's the key in that instance. I'd like to turn and spend some time on just access issues. As I indicated earlier, there are instances in the law where there are many kinds of records that are almost per se open to the public. Some of the easiest examples are court records. Unless the judge in a particular case as to a particular document has issued a protective order, court records are except in certain kinds of cases, juvenile cases, for example.
Is Roger Witzel here? No, Roger? Would like to step out there, sir?
Okay. Help me. What was I saying? Court records. Okay. I'm sorry. I'm just having a senior moment. So there are there are quite a number of records that are just per se open to the public. There are, by the same token, on the other side of the spectrum, literally hundreds of examples and the public records law recognizes that except as provided under state and federal law, that records must be accessible to the public. So there are really, between the state laws and federal laws, there are literally hundreds of specific statutory exemptions. I'm not going to talk about specific ones unless people happen to have a question, but in general, I have found that the custodians of those records this particular kind of record are much more knowledgeable about the exceptions than a generalist like myself. But there are many, if you want to get a sense of the range of these kind of exceptions, the index of the statutes actually has quite a long list of statutory exceptions. There are some exceptions that right now are particularly sensitive or difficult to interpret or to identify the scope of. For example, in 2003, the legislature added to the statute a series of exceptions that deal particularly with employee records, records of state or local government employees. And those exceptions have clarified the laws in some areas. For example, home addresses and home telephone numbers of employees are not available to the public unless the employee consents. But there are some areas, and these provisions are set forth in 1936, paren 10 of the statutes, where there really is some lack of clarity and fertile ground for litigation. And I'll just leave it at that. If you have a record, or you're a requester who wants a record that isn't covered by one of these automatic access provisions, or it's not covered by a clear statutory exception, then the custodian has to apply what is called the common law balancing test. And first of all, before they do that, the custodian should, I think the little handout as well as the materials set out just a useful analytic step-by-step process to follow. You ask yourself, is there such a record? I mean, if there's a request and the record doesn't exist, you're not compelled to create it. Or if you don't have it, all you need to do is you tell the requester that you don't have custody of such a record. Is there an absolute right of access? Is there an absolute denial of access based on the statutes or the common law? Now, there are some exceptions under the common law that I failed to refer to. One of the ones that's been recognized most recently is the exception for prosecutors' records. I happen to think that records that are covered by attorney-client privilege, and that is records that are legitimately covered by attorney-client privilege, are probably subject to a common law exception. I think there's language in recent court decisions that pretty clearly suggests that. But if you're in that gray area where the answer isn't clear, you need to apply the balancing test. And the balancing test requires the custodian to weigh the public interest favoring disclosure, and remember that's a presumption, favoring disclosure, against the public policies that favor confidentiality. And it's important to remember that this is a balancing of public interests. It's not a balancing of private versus public interests or personal versus public interests. Sometimes the law recognizes a public interest in protecting personal privacy or in protecting certain kinds of other kinds of rights of privacy. But it's something the public interest needs to favor. So that in this area, I think that applying the balancing test, and in many cases, the presumption, you look at it, you say, why not? And if that's your answer, that's pretty much your answer. If it's why not, the answer pretty clearly favors disclosing the record. But sometimes you really do have difficult situations, there's something that really, from the custodian's perspective, may be really troublesome about releasing a particular record. And in that regard, I think quite often, if it's a difficult question, that's a signal that it's a good idea to consult with legal counsel if you have available, or any of the other resources that are available to you, whether if you're a custodian, a local custodian, the Towns Association, the League of Municipalities, whatever, call our office. I mean, we talk about these things. We talk about these things with requesters who call as well. Just try to sort out what the interests are on one side versus the other. The key is there's no one answer. Even if it's the same kind of record, the context may be different in a particular case, or the timing may be different. Now, one interesting area that there's been some litigation and case law precedent on that kind of illustrates that is investigative records. The Wisconsin Supreme Court went out of its way in a case called Linsmeyer versus Forsey that was decided, I think, in 2002, to try to give, usually they shy away from giving general guidance. They tell you, no, we don't do that. But in that case, they really went out of their way to try to give some kind of guidance to, especially to law enforcement agencies, about different kinds of law enforcement records. And in that case, they did recognize that where there is an ongoing law enforcement investigation, the records are not automatically closed. However, the presumption, in a sense, flips toward non-disclosure if, in fact, there's an ongoing law enforcement investigation. Now, that doesn't excuse the custodian from looking at this record and saying, does it really matter to the investigation? Can it be released without harming the investigation, et cetera? But it gives some guidance to the law enforcement custodian. That case also recites a number of other factors relating to law enforcement records, and it's an important one. If I get calls from police officers or sheriff's offices or whatever, and they don't know about that case, that's the first place that I point them as giving some guidance. But the fact is, and that case also went on to say that once the investigation is closed, and there may be a question about when that happens, if there's an ongoing prosecution, there may be a question of fact about that, but once the investigation is closed, the opinion was quite clear that you go back to the ordinary presumption of access, and again, you apply the ordinary balancing test. But there are no magic answers in this area. For many kinds of records, it can be challenging. You have to look at what, is there some sort of patient confidentiality? Are there certain kinds of privacy rights? Are there certain public interests in having a full and fair discussion of what a public policy decision is going to be, so that you protect the preliminary parts of that discussion from being disclosed? So there aren't easy answers. I'd be the first to assure you of that. And it is an area that can be challenging. If there are specific questions about the balancing test, quite honestly, I prefer to answer them afterwards, because they do tend to become very fact-specific. And I'm going to try to wrap this up in the time that I've been allotted. In the past 10 to 15 years, there has been a lot of litigation. Well, up until 5 years ago, there was a lot of litigation about a requirement when the custodian was required to give somebody who was named in a particular record notice of the release of that record. There was a great deal of uncertainty. It was a real fodder for all kinds of litigation. In 2003, when the legislature amended the statute, they created a provision that's section 19.356. And that provision, although it has some conundrums in it, some language that I find a little obscure and difficult to understand, for the most part, it really did clarify the law in that area, and it makes clear that unless the kind of record that is specifically described in the statute as being subject to the notice requirements, then the custodian is excused from having to give notice. It doesn't prevent, in certain kinds of circumstances, a courtesy heads up that a record might be released, but it does not give the person who is the subject of that record a right to go into court and prevent the release of it. So that area of the law has been largely clarified, so that is helpful. Inspection, copying, and fees. There are a surprising number of problems related to this area. A lot of them right now relate to electronic technology, and I won't go into them in detail, but basically the statute and the case law make clear that the requester has a choice. They can come in and inspect the record if they choose. There are requirements, procedural requirements. If you have regular office hours, records need to be available in regular office hours, or that you have to let them know within a certain period of time. But basically, the requester does have the option, under ordinary circumstances, to come in and inspect the record or to request a copy. This can be problematic if the record requested contains information that has to be redacted, because the custodian then has to, if the request is for inspection, the custodian still has to make a copy of it and still has to redact it and so forth. But the custodian or the requester does have that option. The statute is very conservative about what kinds of costs are authorized. And it makes clear, I think, it's basically another statement of legislative policy, that you have to have an actual necessary and direct cost before it can be charged. For example, the actual necessary and direct costs of copying, actual and necessary and direct costs of mailing. The charges for locating records are limited. You can't just build into your copying fee something called a research charge or something that really is a way of charging up front for looking for a record, because the statute limits search and location fees. And it says that actual necessary and direct costs may be charged for locating records if the costs amount to $50 or more. So if it's just a routine kind of record and it takes you 5 minutes to find it, you can't build into your request that 5-minute increment of your time that it costs to go find it. You can charge the actual necessary and direct cost of copying it. And in that regard, at least as to paper records and conventional Xerox costs, I've actually had the occasion to do some research on that, and at least in the Madison area, I checked with both commercial copiers and who are people I assume have a little profit margin built in, as well as government agencies that do bulk copying. And our office has long held the position that copying fees should be limited to the range of 15 to 25 cents a page, that anything more than 25 cents a page is suspect. that's another thing, like our kind of 10-day rule of thumb that's fairly well known. But I think it's an important one. It's a reminder that you really are limited in what you can charge the public because there is that interest in people having access to records. There are numerous problems relating to the costs of electronic records, and I could probably spend quite a bit of time just talking about the headaches associated with those. I think on the one hand, some requesters have gotten the idea that just because you can do an electronic search for certain kinds of records, there's no cost associated with that, and forget that there are limitations on a request, that you have to reasonably describe the record requested, so that a request, for example, for all emails produced by a government work unit for a period of time, I would not consider to be a sufficient request under the law. It's, as I said earlier, it's grounds to talk to the requester and explain to the requester that this doesn't seem to be reasonably describing the record as the statute requires. But that kind of request has created some real issues relating to costs, as has the kinds of questions that relate to access to specialized databases and the computer programming costs that may be necessary if a person wants a particular kind of report or so forth. And these are kind of things that we're struggling, and the challenge is to try to apply a law that doesn't really give you specific guidance on how to do this, and apply the general principles that are in the law to figuring out what a reasonable answer is. The enforcement options under the law are pretty straightforward. Any requester who has been denied a record request, or for whom you can also sue if you haven't received a response and there's been an unreasonable delay in being provided with a response to your request. All requesters do have the right to seek mandamus in circuit court. That's not a favored option unless the requester has some resources. So the favored option in general is that both the district attorney and the attorney general have discretionary authority to enforce the law. And on occasion, so the first avenue, if you're trying to go that route, I would suggest is to apply to the district attorney, because if it's a local issue, we're going to probably suggest that you do that anyway, if you're really after enforcement. You can also apply to the Attorney General's office, not just for enforcement, because you can always ask for enforcement, but many people apply to our office for opinions on the law. And this is one of the few areas of the law where the Attorney General is authorized to give opinions to the general public. There are some very significant limitations on what other kinds of areas the Attorney General is authorized to opine on, but public records and open meetings are areas where we do and we try to, we think it's an educational function. It's a proactive function that we favor, because education often solves problems much quicker than litigation in many instances. But those are the enforcement mechanisms. I've got a couple of minutes, and if you want to spend some time, we can turn to those questions that are on the back of your blue sheet. And now it's your turn to talk. I'd like to have some audience feedback on this. First question, can your municipality increase its revenues by adopting an ordinance that doubles its per-page photocopy charge for complying with public records requests? So somebody says no. Anybody have a different answer? I think that's the key question. If they're not currently charging the actual necessary and direct costs and they're taking a hard look at tightening up their budget a little bit and that this is an area where they need to revisit their policy, if they really can justify that they need to double their copying charge because that's the actual necessary direct cost, yes, they can. So even though your first answer is to be very suspicious of that, it does depend. Must handwritten notes taken to prepare the minutes of a closed session meeting be disclosed in response to a public records request? Yes, the answer is yes from some people and no from others. Why yes? First of all, if they're notes used to prepare the minutes, those are ordinarily the kind of notes that are truly notes, because the minutes are what the body adopts as the official record. So if they're truly notes being used to prepare the minutes, I think the answer is no on that account. If, however, say you get the minutes, and the minutes are approved, they're no longer notes, then the answer to whether or not you can get those minutes, I think, depends on whether there's a justification that it still exists for maintaining the secrecy of what was described. Now, very often meeting notes don't have anything very revealing in them anyway, so you may not be denied access, but that would be the legal analysis that would be applied in that circumstance. Can a newspaper obtain a list of the names and home addresses of all employees of a certain municipal department for purposes of investigating a local scandal? Okay, no is the general answer.
Unless they're required to reside in the municipality or something like that? Okay.
The trick part to this is that there's two parts to it, names and addresses. Now, as to home addresses, the statute, you're right, there has to be, well, normally home addresses are closed to the public unless the employee agrees to their release. There are some specific provisions that relate to officers who elected officials who must reside in a particular municipality. But I would think, for example, where there's a residence requirement, under the balancing test, because the custodian could release only the fact that you live in the city of Madison or something like that, that would satisfy that interest without necessarily releasing the home address itself. But what about names? Yes. Why yes? Okay, and that is certainly generally the answer. I mean, in general, you're a public employee, you would expect that your name is available to the public. There is some interesting litigation going on right now that relates to public employees who are represented by particular collective bargaining unions, and there are some provisions in a couple of collective bargaining contracts that are restricted to the release of names of employees represented by that employer. at least in the context of records that are not directory information. Our office has taken the position that directory information, a list of all the agency employees is something that's ordinarily available to the public. That litigation is pending in the Court of Appeals and is being briefed, and so there's likely to be a decision, but in general, you're right. The names of public employees is kind of per se the kind of information that's ordinarily available to the public. Can the newspaper obtain copies of the family photographs, or maybe I like New Yorker cartoons that are posted on the bulletin board in my office? No. Thank you. The answer is no. I think that the public records law either are not kept or created in connection with official business. They're kept and created in relation to my personal peace of mind, and I don't believe that kind of materials are a record because they aren't created or kept for official business. And finally, can a person contracted by the town to do its property assessments charge $50 per property for providing assessment information to a local real estate agent?
No, because in the contract, you're going to stipulate that they can't use the information for personal gain.
Well, David, that is, the suggestion was no, because the contract should stipulate that they can't use this as a means of personal gain. And you might have said that humorously, but there is a case recently that really kind of talks about that. And that is, you can't just contract away to your assessor your obligations under the public records law. The public records law limits what the authority can charge to the actual necessary and direct cost of reproducing or copying that record. And it would be a mighty impressive record if it was $10 to reproduce. I imagine there could be one that's hundreds of pages long, but there's a case recently decided, and it's on appeal in the Wisconsin Supreme Court on other issues, but it discusses that issue, and I'm pretty confident that part of the case is a statement of a clear statement of existing law and is not likely to be overturned by the Supreme Court. I thank you all for your attention.